It's only to the position that she needs to go. And she retreats to the position, well, there may have been 3 or 4 just to check, but the other 34 were fine. We know that's not true. It wasn't true then, it's not true now. They counted every precinct and went through every precinct in the pre-count, excluded those. It shuffles and balances, as Mr. Santor said. And but the problem is they forgot to shuffle 3 or 4. And that's how they got caught. Reno Ordini then testified, and Reno testified he is an assistant prosecuting attorney. He works for Bill Mason. He was assigned to the Board of Elections as a legal advisor on Kathy Martin passed away. Reno Ordini testified that he had no knowledge of this until Fran told him. He testified that on December 10th, I believe it was, that he had a conversation. One of the people involved was the defendant Green. The only thing spoken about in that, there were a couple of things. One was the recount of procedure pursuant to the documents it faxed to him. He testified that the documents they faxed to him were the Board of Election policies and the Secretary of State's directive, specifically December 7, 2004 directive. I think it was 2004-058. You got it. He testified nowhere in there, nowhere does it say anything about unsealing the ballots before December 16, 2004, or when the recount date is established by the Board of Elections. Nowhere in there does it talk anything about a hand recount. Nowhere in there does it talk about excluding ballots. None of that. He reviewed that for purposes. And they submitted it to him because that's the recount procedures that they identified. Now, they did talk about this 550. And he indicated to them, have you done that? Always done it. And his understanding that they did. So he said, continue with your past practice. Now they're trying to bootstrap and say, hey, anything's fair. I mean, if we're taking bribes or whatever we're doing, we can do it because they said, just follow what you've been doing. It's absurd. And how Mr. Ordini is corroborated or substantiated his credibility is, number one, you got Fran Lambert that tells you that he called Reno date on December 16th. You also have him being fed the same garbage, if you will, the same story that Cyrus Taylor, Kathy Wynn, and Vicki Lovegren that appear on the tape. That's 550 when asked about how it's done. Don't say anything about pre-count. Also at the meetings, we're talking about this 550, nothing about pre-count. So he is told consistently, as everyone else is, and involved in that meeting is Defendant Dreamer, who just, this is Friday, Monday, as Fran and I testified, they're starting this elaborate multi-day process. Now, Reno Ordini also testified that then he prepared a memo. He wasn't at the board meeting on December 15th. He was there on December 22nd, and George Taylor and other people arrived there, and the concerns were abundantly expressed, replete in the record of the minutes about the concerns. So the Board of Elections and everybody heard it. Reno Ordini then said he had a conversation with a couple of board members after that, saying it was wrong, if indeed that happened or anything happened of that nature. He then testified that, of course, you've got the Christmas holidays, New Year's, they reconvene on January 3rd, and by that time, they see the letter from Rick Gerger. Further detailed concerns and problems they had here. He then says that he reported that to his boss, Bill Mason. You also see in the letter a copy he sent to Bill Mason with regard to Rick Gerger's letter. So Bill Mason then meets with him, and after he puts together a memo of this, he said he believed it was January 20th, a memo outlining what happened and what the allegations were. And after that, he said that he met me months later when he came out here to meet with me about this case, when a special prosecutor was assigned. out whether they're defense witnesses or state witnesses. And I'm talking about Claudette Barth and Mike Florett. Now, Claudette Barth gets on the stand and she testifies. I gather her purpose of her testimony was to say that she worked at the Board of Elections for a while and said that they got involved with this pre-sort process here. It wouldn't be uncommon for them to pre-sort to facilitate the witnesses counting, just putting the candidates. Now, I wasn't clear whether that happened recount day, in the morning, or when that happened. Folks, if that's all that happened here, we wouldn't be here. But it did happen. One of their things is saying that this always happened. This has been going on for years. Well, I didn't hear any testimony there. Because what we know happened here is far more extreme than that. We know what happened here was not only that they pre-sorted, they pre-counted, and then they compared with the official canvass, and they excluded those precincts that didn't balance with the official canvass. For what purpose? As Claudette Barr said, there's a much higher, strong likelihood probability that you're going to get the same result through the machine when you run it through with the witnesses present. No recount of the county of the entire county. And she testified that they would have been mandated to make over 600,000 ballots in this particular election, a full county-wide hand recount, if it didn't balance. I asked her, did you ever do such a thing? No. The answer was no. Would that be improper? Yes. Would that be random? No. Claudette Barth, their witness. To make matters worse, they call Mike Florett. Secretary of State's office was given the same deal. He's told about the 550 in larger counties. Never told anything about the pre-count. Just like Rainier Regini was, just like Cyrus Clare was, just like the board meeting December 15. Talked about 550 billion. We didn't touch what really happened. So Mike Florett gets on the stand, and Mr. Rotatori asked him, if I remember correctly, were you aware of the methods that the board election or these employees were implemented for the recount? And essentially he asked him, did you approve? Were they defined methods? And he said, yes. So I get up and I ask him, well, geez, Mr. Florett, did you know the recount? No. Did you know that they compared that with the official canvass? No. Did you know that they excluded based upon not balancing? No, I didn't. Would that be improper? Yes. Would that be random? No. And other than Mary Eisler, I believe, today, which is essentially the character of this for those who agree, that's the defense. Talk about transparency. I could have called it in the state's case. She thought it was my witness. But that's what we don't have in transparency. Mike Florett from the Secretary of State's office, who's no longer there. He's free to testify to anything he wants. He's on his own. He came in and testified truthfully as to what had occurred here. And he said, the object of the law, as the judge indicated, that's one of your things here, willfully violating duty. Okay, and hinders the object of the law. That's one of those, count 1 and 2, part of that. This is important. I said, isn't the purpose of these recounts so we can all count together? Yes. And isn't it for purposes that we ensure transparency? It's all open and honest. Yes. The evidence is overwhelming, folks. The evidence is beyond any reasonable doubt. And what I mean by that, is it reasonable to come to any other conclusion? It's not. Other than that they violated the laws, their duties in those laws, essentially making sure that sealed containers and only opening them in the presence of the witnesses, and also making sure that there's a random selection. It's not reasonable to come to any other conclusion. There's no reasonable doubt. only reasonable conclusion you can come to based upon the evidence is that they're guilty for each and every count for which they've been indicted. Now, I will have a chance to talk to you again, but certainly think about the evidence,